Hi, everyone. Harry here to talk about the denial of a Public Records Act request in Arizona by a Republican group with a history of spreading election conspiracy theories and harassing election workers. All right, this is very much of a piece with things going on all over the country. We are in Arizona, swing state, and Republicans are basically putting together phony baloney or groups just put together for the election in order to take actions that would have the effect of reducing potential Democratic voters. And then we'll see a whole different set of actions after the elections. And we have here We the People Arizona. And We the People Arizona is a Republican group led by a Republican whose name is Shelby Bush, a RNC delegation chair and member. And Shelby Bush has presented false claims of mismatching signatures in the 2020 election, and she also has said of an election worker, if this person were in the room, I would lynch him. I don't unify with people who don't believe in the principles we believe in and the American cause that founded the country. So you get a flavor of where she and this group is coming from. So they asked for public record of what basically all election workers and people who have worked with election workers and all the people who did signature verification in the 2020 election. And they're wanting to say, among other things, that they did it too quickly, so it's both backward-looking and forward-looking. Now, public records requests like this are presumed there's a right to the public to know, so you need a reason to overcome. And here, in fact, the reason the judge found that it was overcome in order especially to protect the identity of election workers and to be able to recruit election workers. So the judge said that there is this standard assumption of public access. However, here we had all this evidence at the hearing about the alarming threats that election workers personally received from these guys, and including 50 threats, harassing messages, accusing them of committing a crime and stealing the 2020 election. Ultimately, they had to install a filter, and then additional credible testimony about other threats and a whole sort of intense campaign by these folks. So based on that, the judge said this has also been a kind of a pattern. At least it was in 2020. We'll see if it goes on and continues. The group basically didn't get discovery, didn't do anything. It just makes these kind of conclusory claims. So they didn't even really get involved here. They just said, they filed on the cheap a request to inspect public records. And so the court finds, this is the sort of core finding of the opinion, the court finds that the recorder, so the recorder here is coming in and saying, don't make me do this. I know there's a public right generally, but I don't want to have to disclose names because these guys will do nothing but harass my folks, keep me from being able to hire people, and generally distort the process. So, court finds that the recorder has established legitimate security concerns about public disclosure. That's the other thing they could do. It's, send it around on the internet, dox these people. You have to remember, until 2020, election officials were retirees, nice, calm, mild-mannered people for the right to vote, but not advocates. And out of nowhere, you get these cyclones of rabid, typically Republican workers making their lives miserable and upending them completely. So the court finds that legitimate security concerns, the threats and harassment that these employees are alarming and persuasive. So we want to both blunt those, and also there's a chilling effect. They won't be able to recruit people. So you couldn't get temporary workers. You need that in order to be able to fulfill your mission. So the recorder has given a list, so it's somewhat narrowly tailored they just want the lower level non-managerial employees. And the recorder's not saying public officials who are elected and have the official political responsibility and accountability to the people. You can know who they are and you can come after them or insult them. But what you can't do, and what the Republican group has done in Arizona and loves to do nationwide, is come after lower level managerial employees, retirees who come on to do their civic good deed and help with an election and find themselves in a maelstrom of threats and insults and, why in the world do they need this and would they volunteer? So it applies only to that. There's another way in which the recorder is going to identify these people by number so you can talk about them but without threatening them personally. And then there's just a final thing about, you have to be very careful not granting public requests, and you can't just do it against a speculative or hypothetical risk. But here, we're not talking about hypothetical threats. Defendants' line employees have been the target of actual credible threats, and they're not for employees just because they're employees, but people who, because of their duties, are going to be the targets by this Republican group formed basically for this purpose. So they grant the request, and it is now, they're going to withhold the names of the lower level non-managerial employees. I assume an appeal lies here, and you can expect that they will do it. There's, really no stone unturned in these policies in different states, especially the swing states, Arizona being one of them. So we will see whether they'll be able to protect the especially temporary workers from coming in and being the subject of all kinds of intimidation and harassment. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.